Web. All right. Welcome, everybody. Welcome to the meeting of the Standing Committee on Economic Development and Environment. And are we ready to get started? To kick things off, maybe I'll ask our former MLA for the Sawtoo and Chief for Dene Nation, Norman Yakalaya, to lead us in a prayer. So I'll ask everyone to stand.
I'll say Sultane. It's Norman Yakalaya. In my language, I said, thank you, my people. Sultane, Kunason. Outside's really beautiful. And I wanted to thank the MLA chairperson, Corey, for asking me to say a prayer. I asked the elder if he say the prayers. He said, no, it's okay, you can do it. So I have permission from the elder to say the prayers. We usually ask our oldest person, because they lived the longest before us, more wiser, kinder with their words than a former MLA, to say a prayer. And so I wanted to say that we ask for good guidance and discussions and thoughts and prayers into this important legislations that our committee members are hearing on behalf of our people and our thoughts and the people that we represent, that to give us guidance to the direction as we see this legislation happening, because it's for generations before us are going to come, and this legislations are going to affect all people in the Northwest Territories and the representatives of the groups that we represent, and that's the Dene National Chief. I'm very honored to say the prayer on behalf of the old ones back in our communities. And that as this committee travels and hears bills and hears concerns, visit our communities in Denede, that they pay respect when they go to our community by offering tobacco, mattress, or on the land for the ancestors that they're visiting, and taking their considerations as they hear these bills. And safe travel to these members, because they have families like us. And safe travels when they listen to people in the Northwest Territories. We come together and we think with good minds and good hearts, and that they put this report together for us that speaks to the wishes of the people. And so we pray for the people in the hospitals, the ones who are in jails, the ones who are struggling in the streets, and we pray for our families, and we pray that we have a good spring. We don't know why this weather's this way. Only God knows, and only the land knows. It's taken care of itself, and the land is telling us something, because we're talking about things on the land, the forestry, the minerals, the protection. We are talking about our land, and we're talking about what's good for our land. And so I ask this in our prayers. You say it in your own way, and that's the right way. So thank you, Mr. Chair, for allowing me to say the prayer today for the people, and thanks for the elders for giving me that okay to say it. And Masicho.
Thank you. Thank you, Chief Yakalaya. Once again, everyone, welcome to our meeting of the Standing Committee on Economic Development and Environment. Take this opportunity to introduce to you our committee members. To my right is, well, actually we've got I'm so used to being on the road and having to do the introductions, but I'll get the members themselves to introduce themselves. Start with my right.
Kevin O'Reilly, Frame Lake.
Karen Tester, member for Cam Lake. Good evening.
My name is Corey Van Thuyne. I'm the MLA for Yellowknife North and the chair of the Standing Committee. We also have with us here this evening, to my right is Michael Ball, our committee clerk. To my left is Stephen Dunbar from our research department. And we also have, working hard downstairs from our Public Affairs Communications Department, Chris Cartwright. Today, the Standing Committee on Economic Development and... Oh, sorry, and I apologize. I'll let RJ, please introduce yourself.
RJ Simpson, MLA for Hay River North. Thank you all for coming. I'm sorry I couldn't be there. I have work in Hay River. I couldn't be here, but I'm happy to participate via phone, and I'll be watching you all on satellite. Thanks.
Thank you, RJ. Today, the Standing Committee on Economic Development and Environment is holding a public hearing on Bill 38, the Protected Areas Act, Bill 39, the Environmental Rights Act, and Bill 44, the Forest Act. The Standing Committee on Economic Development and Environment is a committee of regular members of the Legislative Assembly. The bills we are reviewing today were introduced by the Minister, given first and second reading in the Legislative Assembly, and then referred to this Standing Committee for review. Legislation is typically brought forward by Cabinet and is reviewed by Standing Committee. The members of this committee are responsible for holding the government to account. And one of the ways we do this is by making sure that proposed laws are supported by the people of the Northwest Territories. It is our responsibility to consult with residents on what they'd like to do or what they'd like to see about the bills. We would like to hear your views and comments, which will be used by the committee to identify any changes we would like to see made to the draft legislation, and which will then we will report back to our colleagues in the Assembly. The Standing Committee held public hearings on these bills in Fort Smith, Katloditchi First Nation, Hay River, Fort Providence, Betchico, Inuvik, and Norman Wells before holding our final meeting here this evening in Yellowknife. We then will report back to the Legislative Assembly on the proposed legislation during the upcoming August sitting of the Legislative Assembly. I wish to briefly describe the intent of these bills. Bill 38, Protected Areas Act, proposes to establish new legislation that will allow the GNWT to create permanent protected areas in the NWT where there are important plants, animals, land, cultural, or historical sites. It also allows for co-management of a protected area with an Indigenous government or organization. This bill says what is allowed to happen in protected areas and what is not allowed. Mining exploration, oil and gas development and exploration, and energy developments are prohibited. Small-scale renewable energy projects may be developed within a protected area or by an adjacent community. Roads or power lines may be permitted with consultation of the Protected Areas Management Board. Bill 39, Environmental Rights Act, proposes to change the existing legislation by protecting people's rights to a healthy environment, help ensure that the GNWT always considers how the environment could be affected, and investigate when a person reports to the minister that someone has harmed or could harm the environment. Gives residents of the NWT tools to help the GNWT protect the environment. The GNWT must write a report every 4 years on the state of the NWT's environment, which will be reviewed by the Legislative Assembly and allow time for public comment. Bill 44, the Forest Act, proposes to establish new legislation that will provide tools for managing forests and the use of forests in the NWT to keep them healthy, provide tools to prevent and respond to wildfires, create forest harvesting agreements, permits, and licenses, allows the GNWT to create rules around harvesting timber and create rules on burning outside communities, allows the GNWT to create rules for harvesting of other forest resources such as berries, mushrooms, and other plants, and to respond to insects, invasive plants, and forest diseases. So for those who may not have already, there are copies of the bills and plain language materials on the side table, so we encourage you to help yourself. And if you'd like to share your views with us today, please let the clerk know now. And I think we've already gone and done a round, so we pretty much have a list of who is willing or who is going to be speaking this evening, and we have an order that we will be following. And what I'm going to do is ask that when the presenters come up, that whether you're speaking on one bill or all three bills, we would like those witnesses to remain at the table and speak to everything they're going to speak to this evening, rather than speaking on a bill and then getting someone else to come in and speak on the same bill. We're just going to keep the witnesses at the table until they're complete on the bills that they're going to speak about. I do remind folks that we will be taking written submissions if you haven't already submitted any, and or if you care to give your presentation to us in writing, we'll take any written submissions of any kind up until May 3rd at 5 p.m. One final piece of housekeeping. Please remember that all submissions will be part of official committee records and may be reflected in our final report. Any submissions made during this meeting may also be televised or broadcast via social media. So thank you, everyone, for your patience in allowing me the opportunity for this introduction. And with members' agreement, we can now open the floor to comments from the public. Do members agree? Agreed. Thank you, members. So first on my list, I would like to ask to come up to the table. I'll have Karen Hamry come up to the table, and I believe we have Professor Linda Collins on the line. Professor Collins?
Yes, indeed. Yes,
Okay.
Thank you, Mr. Chair.
Just one moment. And are we actually having a presentation? Okay, so it's going to be by phone. Okay, thank you. And Ms. Hamry, I'll turn it over to you for your introduction and opening comments. And don't worry about the microphones, people.
Okay.
We have our audio-visual technician, Jeff Petrie, in there, and he will manage, and the correspondence just goes through the chair, and we'll know when to switch the mics.
Thank you.
And I believe it's that mic that you're going to speak to. Thank you.
Okay.
Over to you.
So, thank you for the opportunity to speak. And my name is Karen Hamry, and I'm going to be introducing Professor Collins. The committee has a technical paper that Professor Collins did on the Environmental Rights Act, and so she will present and answer questions on behalf of 5 organizations: Alternatives North, Ecology North, Canadian Arctic Resources Committee, Council of Canadians, the NWT chapter, and Canadian Parks and Wilderness Society, NWT chapter. So these are nonprofit organizations, and we've compiled our resources to get expert advice on this very important piece of legislation. And you also know that Professor Collins' submission was endorsed by the United Nations Special Rapporteur on Human Rights and the Environment, Dr. David Boyd. So I really encourage you to take this opportunity to make the most of Professor Collins' expertise on this matter. We do have one additional point on the ERA before turning the floor over to Professor Collins. At your meeting in Hay River, we heard that the Northwest Territory Métis Nation had a suggestion on who should be allowed an investigation. Section 8.1 says any adult resident in the NWT may apply to the Minister for Investigation. And the Métis Nation suggested change to any adult resident or Indigenous government. So we agree that an Indigenous government should be given the right to apply, but we would broaden that to say any legal person resident in the NWT. This allows IGOs, municipal governments, non-government groups such as ours, and youth to apply for an investigation as well. It is a very simple but important change. Professor Collins has addressed other aspects of Section 8 in her paper, such as deleting the requirement to swear statements before a commissioner taking oaths. So I'll now turn the floor over to Professor Collins.
Okay, thank you. Professor Collins, we'll turn it over to you. And Ms. Hamry, if you don't mind just leaning that microphone a little bit closer to that speaker, we appreciate it. Thank you. Yeah. Oh, we have one.
Thank you, Mr. Chair, and thank you to all the honorable members. It's very kind of you to have me. I wish I could have visited you in person. I hope to have a chance to visit your amazing land sometime soon. And it's an honor to have an opportunity to comment on this bill, which I know is intended to help you all steward that land, both for the immediate and the long-term future. And I think it's a very laudable effort to modernize what was, in fact, a groundbreaking statute when it came into force. There's one thing that has changed dramatically since the first act was written, and that is a very robust and compelling body of international scholarship has come into being that has proven to us that substantive environmental rights make a difference. So for many years, people like me were writing to say we should recognize the right to a healthy environment, but it was largely just an academic idea. And about 10 years ago, David Boyd began researching the existence of these rights in every country around the world that legally recognizes the right to a healthy environment. And he asked what was then, for some of us, a very scary question. He asked, do these rights matter? And what he found is that, in fact, legally enforceable rights to a healthy environment make a big difference. So they improve environmental legislation, they improve litigation outcomes, and most importantly, they improve environmental outcomes. The cleanness of air and water, ecological footprint, sustainability, climate impacts are all improved in countries that have an enforceable right to a healthy environment. And the great news, too, is that what we haven't found is any compromise of economic well-being in these countries that have this right. So, for example, Norway, which has a climate and economy quite similar to Canada, has an enforceable constitutional right to a healthy environment. And their economy has seen some of the strongest performance of any economy in the Western world. So we know that, in fact, not only is there not a trade-off between the right to a healthy environment and economic well-being, but actually they are very much mutually enforcing, mutually supportive. So my first recommendation that I want to emphasize today, because I know you have the written submissions, and I don't propose to just repeat everything that I said, but can everybody hear me?
Yes, you're doing well. Thank you.
Yeah, okay, sorry. I just heard a little beep there. Great. I'm not my computer, so feel free to email me if anything goes on. So the most important recommendation that I want to make is there should be a freestanding provision recognizing the right to a healthy environment. In the current draft, the right is recognized in a very kind of watered down way in the purposes section, with modifying language that says, you know, the right is recognized to the extent dealt with in this act, whatever. And that is quite a limited, and I think actually quite an ineffective way of recognizing the right. Essentially, really to a lawyer, what that says is just the rest of this act should be recognized. Whenever we say that a right is recognized to the extent provided for in this act, it's really just a way of saying you should read the rest of this act and enforce it. So it really doesn't add anything, and it's not going to bring these benefits, these tangible and important benefits that we see from the recognition of a legally enforceable right to a healthy environment. So I think you need a new Section 1, or you could call it Section 1.1. We don't want to change all the section numbers. Recognizing the right to a healthy environment, and I've spelled out specific language which is drawn from best practices in Canada and around the world, from the peer-reviewed academic literature, and from the most effective governments that are doing this. I also suggest that, in order to really effectuate, to give effect to the right to a healthy environment, we have to really understand what a healthy environment is. And again, luckily, scholars have been working on this for many years, and I've offered a definition of healthy environment as an environment that is ecologically sustainable over time, and that includes clean air, safe food and drinking water, a stable climate, non-toxic environment, and flourishing biodiversity. And this, again, comes from sort of the laboratory of decades of experience around the world with environmental rights. So this is a definition that would be non-contentious among experts, and I think is one that obviously legislators can understand, but also scientists and courts as well. The next recommendation also pertains to definition, and I've just offered a possible definition of significant, since that significant harm threshold does recur throughout the Act. I'm going to move to another key recommendation, since I'm trying to stick with highlights here, and that is the recommendation to add a new section that would recognize key environmental law principles. So again, over the past 20 years or so, both internationally and certainly within Canada, legislatures and courts have come to develop a body of basic principles of environmental governance. So these are the principles without which you can't really have a highly functioning environmental regulatory system. You could think of these almost as kind of analogous to the basic principles that we have in our charter. So we understand you can't really have a democracy without freedom of expression, equality, freedom of religion, etc. Well, this is very similar. You can't have an effective system of environmental governance without certain minimum and very important principles. And these are the precautionary principle, the polluter pays principle, the principle of ecological sustainability, the principle of intergenerational equity, and the principle of environmental justice. I'll just give one sentence on each. I know you've got a lot to cover. But the precautionary principle just recognizes that there's a huge amount of uncertainty involved in human interactions with the environment. And so when in doubt, we should be cautious in environmental matters. Polluter pays principle is exactly what it sounds like, that when an entity has damaged the environment, that entity should pay to restore it. And again, this is well recognized, has been recognized by the Supreme Court of Canada, similar to the precautionary principle. The principle of ecological sustainability just recognizes that we do want to maintain an environment not only for the next 2 years or 5 years, but for the next 100 and 1,000 years even, that we need to take measures to make sure that the environment can be self-sustaining so that our kids and their kids can enjoy the same quality of life or a better quality of life as we do. And that leads directly to the principle of intergenerational equity, just the idea of fairness to future generations, that, we've had the ability to live in an environment where we can breathe safe air and drink clean water, where there's forests and biodiversity, and most of us have enjoyed a stable climate for most of our lives. And we should be endeavoring to pass those things on to future generations. And then finally, the principle of environmental justice. This refers to a fair and just allocation of environmental benefits and burdens. And this is something that Northerners would be very familiar with because we've had sort of a north-south injustice, for example, in air pollutants, and that a lot of the industrial activity that generates bioaccumulative air pollution is actually in the south, where I live, and that's improving people's quality of life here, but a lot of it actually migrates up to the north. So that's an example of environmental injustice. There's all kinds of ways that regulators can minimize those injustices. That's been done in various jurisdictions, both in Canada and the U.S. and other places, and it does work if we're aware of it. So then subsection 2 of that section would say that every department must consider these environmental principles when making a decision on a matter that may have a significant effect on the environment. So we have found that when regulators are aware of these principles and thinking about these principles when they're making decisions, then we get better decisions. And again, these decisions that respect these principles improve environmental sustainability, social well-being, and economic prosperity. So they really all do go together. Another important recommendation in my mind is to restore a paramountcy provision. So this pertains to Section 5 regarding land resources and self-government agreements. And this section appropriately obviously says that those agreements with Indigenous peoples take precedence over the rest of the Act. But I'm just saying you don't actually need to lose the general paramountcy provision that was in the existing version of the Act, which did say, as with all rights-based acts, they usually include a provision like that that says basically, since this is an act designed to protect people's rights, if there's a conflict between this and another statute, the rights-based statute prevails. And you can absolutely still leave the deference to Indigenous agreements and instruments, but just restore a general paramountcy provision. With respect to Section 8, which is the application for an investigation, which is a great idea, and definitely that should be maintained in the bill, but there was this little addition of the requirement to swear statements before a commissioner for taking oaths. And I certainly understand it's a well-intentioned provision, but it really does restrict access, particularly to people that are living in more remote communities that may have trouble accessing a commissioner. It's going to add an expense. It's going to add a hassle. It's going to make it less likely that people use that provision, which is really not what you want. The point of these procedural rights is actually to maximize public participation as much as possible. And again, the data shows us that when there is robust and informed public participation, you get better decisions as well as less controversy, less litigation, less expense in getting things done. So participation is really good for everyone. And it would make sense to just remove that requirement to swear before a commissioner for taking oaths. I've made several recommendations that pertain to constraining the discretion of the minister. Now, obviously, the minister needs to have some discretion, and none of my recommendations would or could really seriously control that discretion. But I just recommended that there should be some guidance, and in particular, I suggested that there should be a reasonableness requirement in Section 9.2. So 9.2 should read, the minister shall investigate all matters that are reasonably necessary for a determination of the facts respecting an application under Section 8. And that, as you can imagine, is really shouldn't be an onerous requirement, because we would hope that ministers act reasonably, and certainly we rely on them to do so. But it just makes sense to include an explicit requirement, because otherwise it's actually an absolute discretion. And whenever you have an absolute discretion, it essentially means the previous provision doesn't really have any effect, because it's sort of just there as an option for the decision maker, which I don't think is what you want. Section 13.2 is maybe a little bit technical, and I'll leave that in case anybody wants to ask questions regarding standing in public nuisance. I've offered very detailed suggestions for improving environmental enforcement provisions, and those are actually taken from Dr. David Boyd's testimony in SEPA. And again, I can answer questions if there are. And finally, in terms of my tour of highlights, I think that you should consider adding a provision allowing residents of the Northwest Territories to request a review of an existing policy, act, or regulation, or of the need for a new policy, act, or regulation. So this is kind of the complement to the application for investigation. So where an application for investigation is sort of the quasi-criminal side of things, so, allowing residents to bring a possible violation of regulatory requirements to the government's attention, the application for a review process involves bigger picture policy questions. In other words, it allows residents to say, hey, there's something we're not doing that we could be doing through a policy, act, or regulation that would really make a difference for our environment. Either by saying we need to modernize something we already have, or by saying, in fact, we need to bring in an instrument that we don't currently have. And I think that's really quite a crucial part of what we call environmental democracy, or allowing citizens to really have a meaningful opportunity to participate in environmental governance, which, again, as I've mentioned, not only increases government legitimacy and decreases controversy, but it does ultimately produce better environmental decisions. So that would be my survey of the highlights of my submission. I'm happy to go into further detail on any of the recommendations I've mentioned now, or any of the recommendations that I haven't discussed in detail here. So I'll just put myself in your hands.
All right. Thank you very much, Professor Collins, for your comments today, and of course your substantive and detailed submission that you provided earlier, and the backup that and support that Mr. Boyd had also provided is very much appreciated. Members, questions or clarification, points of clarification required from Professor Collins? Mr. O'Reilly.
Thanks, Mr. Chair, and thanks very much Ms. Collins, or Professor Collins, for your written submission. I've had a chance to look it over. One thing that you didn't really cover, I guess I'd like to get your views on whether having an enforceable right to a healthy environment has clogged up the court systems in other jurisdictions. Thanks.
Yeah, thank you for the question. No, it hasn't. There's actually no evidence of that from any of the jurisdictions in which it's recognized. And I think part of that is that litigation is just difficult. It's expensive, it's time-consuming, it's stressful, and culturally in Canada, it's really not people's first move. So there's kind of a whole slew of deterrents to litigation. People really don't tend to litigate until there's absolutely no other option. So what we've seen in this global survey of places that have a right to a healthy environment is it's really litigated to deal with the worst environmental problems. So the kind of situations where you have vulnerable communities that are dealing with life and death pollution, where you have, ecosystems that are really being decimated. That's where we're seeing the right invoked and where it's having some really positive effects.
Anything further, Mr. O'Reilly?
Yep, thanks, Mr. Chair. Yes, the principles that you set out on, I think it's page 8 of your submission, you talked about polluter pays, et cetera. Has Canada signed on to most of these principles? And I can think here in the context of the Northwest Territories, our co-management regimes and land rights agreements actually spell out a number of these principles and implement them through a co-management system. But has Canada as a government signed on to most of these sorts of principles? Thanks, Mr. Chair.
Thank you. Professor Collins?
Another excellent question. Thank you, Mr. Chair. And it's a little bit complicated in that, for example, the precautionary principle and the polluter pays principle are emerging principles of what we call customary international law. Some of you will be familiar with this, so it's essentially unwritten international law. But the precautionary principle and the polluter pays principle have been explicitly recognized by the Supreme Court of Canada as principles of environmental governance. Ecological sustainability, we could have a really interesting academic talk about Canada has signed on to things, for example, like the Rio Declaration on Sustainable Development, and obviously all the climate agreements. So ecological sustainability is certainly a key principle of those soft law declarations that Canada has endorsed. The principle of intergenerational equity, again, has been recognized in some jurisprudence out of the Supreme Court of Canada, and it's mentioned in a number of Canadian statutes. And the principle of environmental justice, I can't think of an explicit endorsement of it, but obviously our charter protects equality, and actually the question of whether unequal environmental harm can violate the charter is currently being litigated by the Grassy Narrows First Nation, and probably will result in a court finding that, hey, if there's really unequal environmental harm in a community, it can violate Section 15 of the Charter. So to various degrees, yes, these are recognized in Canadian statutes and case law. However, what we found is that it's really beneficial to have these principles in the most overarching environmental governance instrument that you have. Whether it's the Environmental Protection Act or an Environmental Rights Act, that it's important when decision makers are trying to understand what environmental rights are, that they have some help, because it's very complicated, it's very ambiguous. It's what the former Chief Justice of Canada called a meaningful generality. And so whenever you're trying to interpret a meaningful generality, you need interpretive principles. And that's what these are. So the departments, as they're going about making their decisions, can kind of run them through a screen of 5 principles.
Okay. Thank you, Professor Collins. Next, I have Mr. Testart. We're going to, in the interest of time, we have to keep this very concise. We have a number of speakers before us tonight. So, and respectfully, Professor Collins, really try to tighten your answers and get them as concise as you can. It would be very much appreciated. To you, Mr. Testart.
Thank you, Mr. Chair. And thank you, Professor Collins, for giving us some very specific things to look at as we move forward in our review of the bill. My question is, what you're proposing greatly strengthens the bill from, I think, a piece of legislation that basically enables this kind of environmental investigation and requires the government to put some more aspirational language into their policy and report on the state of the environment. Some of what you're proposing is almost like a Bill of Rights, an environmental Bill of Rights. Do you feel that if these changes weren't put in place, that the bill would still be effective? Thank you.
No, I don't. Because I've been asked to be concise, I would say no. I don't think the bill will be an effective instrument for protecting environmental rights if these changes, or at least the key ones that I've mentioned, are not in place.
Thank you. Nothing further? If there's nothing further from committee, Professor Collins, I want to thank you for presenting this evening.
Thanks for having me.
Thank you. Next we have Ms. Hamry. You're going to present on Bill 44, the Forest Act?
Yes.
Okay. Okay. So, and again, I just want to remind everyone this evening, which I should have done at the onset, was we're trying to get presentations done within about a window of 20 minutes. We have a lot of people presenting this evening, as you can see. We're not going to shorthand anybody. If there's a need to move the proceedings into a little bit later this evening and or again tomorrow, we'll do so. But over to you.
Thank you. So I'm presenting on the Forest Act now, and again, for the same 5 nonprofits that I mentioned in the ERA. And I'd say, just off the top, we appreciate that SCETI's made up of regular MLAs, and you haven't been involved in the development of these bills. So I wanted to give a bit of background to our written submission that might help you give you some context to our section-by-section comments that we presented in our written form. The Forest Act we see as the most controversial of these 3 bills. The NGOs were not part of the technical working groups, so we can't comment on how well that co-drafting process went or whether the commitments in the co-drafting process are included in this act. We were, however, part of the stakeholder meetings about the 5 acts, so the 3 tonight plus the waters and the EPA. And we're told that the Forest Act was quite far behind in terms of drafting compared to the EPA. And so we were quite surprised to see this one brought forward and not the Environmental Protection Act. And that sense was obviously echoed in the Assembly during second reading of the bill, with a number of members voting against this. And so we, too, have very substantial concerns with how this bill is presented. So that said, we do understand that it is the role of SCETI you don't have the role to kill a bill, but that you're making recommendations to improve it as much as possible and then see what happens at Assembly. So given that, we will do our best to give you what we can in terms of improvements to the bill. I wanted to start off by saying there are a number of very positive aspects to this bill. First off, it brings together 2 bills, brings it into the post-devolution world. It changes the focused ecosystems rather than a forest timber industry focus. We like the recognition of ecosystems, the principles of sustainable forest management and use. It's also very positive that it promotes the development of ecosystem management plans and addresses things like ecological integrity and, very importantly, cumulative effects, and requires forest fire prevention and preparedness plans. So that said, the challenge of combining and updating 2 acts at once has led, in our opinion, to inconsistencies in tone and scope. So, for instance, the words shall and may are used inconsistently, and we point out several areas in in the bill where we think shall should be used instead of the word may. Another inconsistency is how much is left to regulation versus what is in legislation. So we do understand that these bills, all together as a suite, are enabling legislation, giving a framework, leaving a substantial amount of decisions to the regulations. However, here's an example of what's actually included in the bill. A warrant issued under Section 68 or 70 may only be executed between 6 a.m. and 9 p.m. Very, very specific. So, on the other hand, there's only one sentence in the entire bill about the Special Purpose Fund. We understood from the stakeholder meetings that the fund is a very innovative approach for fees for reforestation and clearing to be placed into a special forest fund, and that fund would be used for sounder ecologically based decisions about reforestation and monitoring natural regeneration. So that information is not in this bill, and beyond that, it also has the funds going to the Consolidated Revenue Fund. This does not help us, either as a government or as the public, to monitor how we are doing in terms of restoring our forest health. It clouds accountability with industry, making it harder to figure if the fees we are getting through permits and licenses are indeed covering the costs of monitoring and reforestation. This fund needs to be standalone and warrants additional description in the legislation. We have described in our written report several aspects of annual reporting on this fund. And basically, we want to follow the money and ensure it's truly helping the health of our forests. Another inconsistency in scope regards information to the public. As an example, the bill states that regulations need to include how the forest supervisor tells the public about a fire ban. While we agree that that is important, what is missing are requirements about the broader picture of information that the GNWT needs to provide the public. We're suggesting the inclusion of a public registry, such as is required in Section 9 of the Protected Areas Bill. We want to stress that management and decision-making require public participation. And I would echo what Professor Collins said, that better public participation leads to better environmental outcomes. The bill's preamble states it promotes a cooperative, collaborative, integrated, and adaptive approach to sustainable forest management. And we say, wonderful, that's great. However, we can't have a cooperative and collaborative approach without the public, and the public needs information. So the statement in the preamble is not legally enforceable as such. It does set a good tone, but we need the body of the bill to talk about it as well. The bill does talk about adaptive management in several places. True adaptive management is an open process that involves stakeholders helping to assess management options for improving long-term outcomes. Again, public participation and information to the public is needed for adaptive management. And I'll also add something on the mandate of this assembly, which all the members here were part of. The very first line is governance, and it says improving accountability, transparency, and collaboration. So we have in our written notes suggestions for wording on a section on a forest management registry, and such a registry would help in regards to meeting your mandate. We appreciate this bill includes provisions for forest ecosystem management plans, or FEMPs. This is a good step forward and should address a number of aspects of the forest, our interaction with those aspects, between them and between us and the forest. However, we suggest more information on these plans is needed in this legislation. For instance, it is very important to include a provision in this section for public input into the development of the FEMPs. In the Yukon's Forest Resources Act, their equivalent of our forest ecosystem management plans, are subject to a minimum 30-day public consultation period and must also be shared with renewable resource councils holding responsibility in their particular planning area. Please be sure to include a similar provision for public input, and we suggest at least a 60-day consultation period. So I've gone through a number of points regarding public participation, and monitoring is another crucial aspect for proper management practice. And so we have several suggestions on Section 13, which specifically address state of forest, monitoring the state of forest ecosystems. The health and regeneration of our forests is hugely impacted by climate change. And so it is positive to see climate change in the preamble, but again, it is not addressed in the bill itself. So we suggest adding climate change to the list of monitoring factors, and that is broader than what's currently stated as forest change, and would help draw attention to some of the factors outside the NWT affecting our forests. In this regard, we also suggest adding our ties to the National Forest Network of monitoring plots. We need to continually recognize and acknowledge that the health of our forests is tied to what is happening elsewhere in Canada and in the world, and also that the information that we can provide others will be able to help in global efforts to restore the balance of our out-of-kilter climate. An additional point on monitoring has to do with the NWT audit, which is required every 5 years under the MVRMA. That can give important recommendations on improving management and including recommendations on relationships with co-management boards. The State of Forest report should help track efforts to improving appropriate deficiencies that are noted in that audit. Finally, the public must have full and transparent access to this information. Again, we have included some specific wording on that in our written report. One other example of mismatched scope in this bill is in Part 3 of the bill, Protection of the Forests. Part 3 has 20 sections. 19 of those sections deal with wildfire. Only one section, which is one sentence long, addresses insects, diseases, and invasive plant species. It is odd to leave such an important piece solely to regulations. With so much left to regulations in this bill and the other bills that Sketty has in front of them, we have some suggestions on the process. We realize that the co-drafting process is very innovative and is basically being developed as we speak. We hope that that process continues and is strengthened going forward to enhance reconciliation. And further, we hope that that process is as open as possible. So the 5 NGOs of this presentation asked to be involved in drafting of the regulations for this and other Sketty bills. We ask that you bring this request forward, or please tell us how we should appropriately bring that request forward. In looking to future work, we also have a couple of suggestions. We are not alone in being rather overwhelmed with the amount of work in a short period of time. You committee members, having been on the road now, I'm sure are feeling this quite a lot. Next time, we would like to get plain language information even before the bill comes to the House, or at least at the same time. So for the Mineral Resources Act, the Minister of ITI gave a presentation to the Yellowknife Chamber of Commerce about major aspects of the bill before it came up in the Assembly. We shouldn't have to wait, as we did this time, partway through a very short process to get information on the bills. And of course, the plain language materials should match what is in the actual bills, as was noted in one of the previous sessions. We appreciated the concept of a suite of related legislation being worked on together. This is very valuable. However, the ability of Standing Committee, IGOs, and the public to deal with so many bills at once is truly not realistic. The Standing Committee timelines need to be made adaptable to the number of bills being introduced. These 3 bills are in many ways about our responsibilities as a government and residents to take good care of the land. We NGOs definitely take this responsibility seriously and hope to be able to work with many others to implement this and other important environment and resource legislation. Again, thank you for the time, and I would be happy to answer questions on this or the written submission if you wish to ask.
Thank you. Thank you very much, Ms. Hamry, for your presentation tonight, and we really, as a committee, appreciate the detailed information that you've provided, as well as the previously submitted written submission. And we appreciate not only what you have to offer with regard to the bill, but comments on processes very welcomed as well. Thank you. Committee, questions, points of clarification, Mr. Testart.
Yes, thank you for the detail on the forestry bill. Obviously, this one's been of the attention of many of the committee members based on the context that we were aware of leading up to this review. I'm very curious in your thoughts on process, because that's something that I think we're all thinking about at the tail end of the Assembly. But I do want to note that myself, I'll just speak for myself, I didn't want to see all these bills come all at the same time. And that is a decision of government, not a decision of this committee. The committee receives the bills, we have 120 days to deal with them. So I do agree with you that things need to be spaced out time, there needs to be breathing room, because the public participation in this process is what makes it meaningful. So you don't need to preach to me on why that's important, but it was a choice, and it was a choice that the government made. And we are reflecting on that as well, because this is not the first time we've heard that. I did want to make that clear. As for being involved with the drafting of regulations, I'm not sure, we're not involved with the drafting of regulations as well. So certainly that's a comment we can consider, but typically that is the purview of the executive branch. And I know many Indigenous governments have also asked to be part of that. So there's a possibility that could be opened up to be more collaborative. But at this point, that is the process. But I'm sure you're aware of that as well. So I just wanted to share that with you. This has been a very busy process, and it has not been without some frustration based on the tremendous amount of work that's required to adequately solicit feedback on these bills and do our own research on very extensive bills that are very important to the future of the Northwest Territories. Thank you.
Thank you, Mr. Testart. Not a question there, but certainly the comments are noted with respect to the comments you shared with us. Next, I have Mr. O'Reilly.
Thanks, Mr. Chair, and thanks, Karen, for your presentation. We've heard a number of these concerns before about may versus shall in terms of mandatory duties on officials and ministers and so on. So, but I have one specific question for you. You've noted in your written submission that forest harvesting agreements should be consistent with or in compliance with or conform to the approved forest ecosystem management plans. You didn't mention forestry licenses or forestry permits, which are likely to be, for cutting of timber or maybe even gathering of mushrooms and so on. Should those be consistent with a forest ecosystem management plan? Thanks, Mr. Chair.
Thank you. Ms. Hamry?
Yes, they should be, and we'll put in a supplementary written on that.
Anything further, Mr. O'Reilly?
No, thanks. I do appreciate that there's some very specific suggestions here, and I'll do my best to incorporate a number of these. Thanks, Mr. Chair.
Thank you. If there's nothing further from committee, well, thank you again, Ms. Hamry, for your presentation. I'll give you a moment to get organized there. The next presenter, I would like to call upon President of the North Slave Métis Alliance, Bill Inge. While Bill's getting ready, I just want to remind folks once again that we're trying to do our best to keep presentations to roughly around the 20-minute mark, and keeping in mind that we always usually we'll have a couple questions from committee following your presentation. With that, I'll turn it over to you, Mr. Inge.
Thank you, Mr. Chairman. As the chairman noted, my name is Bill Inge, and I am the president of the North Slave Métis Alliance. And for the benefit of some of the attendees here tonight who don't know who I am the representative of the only Aboriginal group that has proven in 2 separate court cases in 2 separate courts that the members I represent possess Section 35 Aboriginal rights in accordance with the common law of Canada, which has been established under the auspices of what's called the Pali Test. Now, this government knows full well what that means because I've been in 2 litigations respecting the government of Northwest Territories and our Aboriginal rights here on the north side of Great Slave Lake, particularly a harvesting matter where the government of the Northwest Territories, Department of ENR, decided that we didn't have a right to harvest caribou, which I had to get straightened out in a court case. Having said that, committee members, on behalf of the North Slave Métis Alliance or the NSMA, I wish to welcome you to the shared traditional territory of the Cleecho and Acacho First Nations and the North Slave Métis people. I would also like to thank you for the opportunity to speak at this public hearing respecting Bill 38, Protected Areas Act, Bill 39, Environmental Rights Act, and Bill 44, the Forest Act. NSMA was and is an active member of the technical working groups that collaboratively drafted these 3 pieces of legislation. In that respect, I have 3 points to make tonight. First, NSMA commends the government of the Northwest Territories and the Department of Environment and Natural Resources, which is a switch, on the collaborative, cooperative, government-to-government approach it took to drafting these 3 bills. The working group meetings were forums where these draft acts could be jointly discussed, considered, and drafted by the GNWT and Indigenous governments and organizations, including the North Slave Métis Alliance. Everyone involved worked hard to craft modern, made-in-the-North legislation. We look forward to continuing to work this way with the government of the Northwest Territories on future projects. Second, the North Slave Métis Alliance is pleased to have worked with the Department of Environment and Natural Resources to meet its goal of crafting a new piece of legislation for the Northwest Territories, the Protected Areas Act. We look forward to engaging with the government of the Northwest Territories on the final work to establish the Tai Deni Neni and Dinga Wakodi protected areas. Third and finally, the North Slave Métis Alliance commends the government of Northwest Territories for updating other aspects of the Northwest Territories environmental legislation, including the technical working group's efforts to update the Environmental Rights Act and the Forest Act. We know that the government of the Northwest Territories team who made the final updates to the Forest Act prior to its submission to the legislature in February of this year worked very hard to meet the timelines involved. Those timelines mean that there was not time for one final meeting of the working group prior to review the Bill 44, the Forest Act. The Environment and Natural Resources recommended technical working group members provide any feedback on the bill to the committee directly to assist you with your review. For this reason, we take this opportunity to highlight to the committee one missing piece which would otherwise have been dealt with at the aforementioned working group meetings. Bill 44, the Forest Act, does not contain a clear statement that people with Aboriginal rights do not need a permit or license to exercise their Aboriginal rights. Both the Wildlife Act and the Draft Protected Areas Act, at sections 17 and 27 respectively, have these statements. The government of the Northwest Territories should align the Forest Act with the other GNWT legislation, Wildlife Act, and Protected Areas Act. That said, we look forward to seeing the final draft of the legislation after the committee's review. In conclusion, the North Slave Métis Alliance supports the collaborative process that brought these three bills before the committee and asks the committee to recommend one amendment to the Forest Act to make it consistent with the other Northwest Territories legislation, to ensure the Northwest Territories Aboriginal people can continue to exercise their rights on their traditional lands in the Northwest Territories. Thank you very much for the opportunity to speak to you about these three pieces of legislation. And as you can see, it's short and sweet and less than 20 minutes.
Thank you, Mr. Inge. Thank you very much. I'll ask you to sit tight for just one moment.
Yeah, sure.
I really appreciate you sharing your comments on behalf of the North Slave Métis Alliance, and the committee appreciates that. Are there any comments or points of clarification required from committee members? Mr. Testart.
Thank you, Mr. Chair. Thank you, Mr. Engie. We've probably learned more about the technical working group and the co-drafting process over the last week than we have in 3 years. So it's been really informative for me to be able to hear from Indigenous participants in that group and the work they've done. This is a similar concern around Bill 44, around treaty rights and Indigenous rights that aren't properly reflected in provisions of the bill. This committee can, of course, move to make amendments to the bill, but the minister has to agree. So we can't guarantee anything at this point. We can take things into consideration. If those changes can't be made, though, along the lines that you've suggested, do you think the legislation is adequate in its current form? Thank you, Mr. Chair.
Thank you. Mr. Inge.
Thank you, MLA Testart, for that question. And the easy answer is no. But it doesn't seem to me like there should be an obstacle to the amendment we are suggesting, because all it is an alignment of existing legislation already in effect. So we don't see this as a big hurdle for this committee or the drafters to make that amendment, to bring it in line with the other legislation that's already in existence. Thank you.
Thank you. Nothing further, Mr. Testart. Mr. O'Reilly.
Thanks, Mr. Chair. In the travels we've done so far, we've heard from some other Indigenous governments, excuse me, and co-management bodies that they would like to have the concept of co-management better incorporated into the bills through notice provisions or requirements for consultation with Indigenous governments or co-management bodies before decisions are made. You haven't said anything about any of that. Does NSMA see themselves, do you want to get notice under some of the provisions in here? I'll just pick an example. Say for a forestry agreement, if a forestry agreement were to be negotiated in your traditional territory, would you want to be consulted during that process? Because the bill is, at a high level, it says that it can't derogate it from Indigenous rights, and that completed agreements are to be recognized and they have precedence and so on, but there's no explicit incorporation of co-management in the Forestry Act, almost nothing. So do you see NSMA, or should NSMA have the ability to get notice or be consulted under the Forest Act in particular? I'll just use that as an example. Thanks, Mr. Chair.
Thank you. Mr. Inge.
Thank you, Mr. Chairman. Thank you, MLA O'Reilly. Of course, the North Slave Métis Alliance would like to be consulted about legislation that the government of the Northwest Territories is drafting that's going to have an effect on the Aboriginal rights of NSMA members. However, just recently in the last year, there was a Supreme Court of Canada ruling, and it's called the Mikisew Cree case, where it was decided under Canadian law that governments don't have to consult Aboriginal peoples before they produce draft legislation or bring legislation to the legislatures for consideration. I think the government of the Northwest Territories is taking the right approach by even considering that, considering they don't have to do it. And of course, we would want to be consulted about any legislation that would have an effect on the Aboriginal rights of not only the North Slave Métis Alliance members, but also our other Aboriginal counterparts in this territory. So indeed, we would want to be consulted, and it would be, I think, the best way to go in order to ensure that the legislation that this government is wishing to get passed would have a smoother facilitation through the process, instead of finding out there's going to be huge legal obstacles to it at the end of the process. So I think it's always better to include the Aboriginal peoples in the process to ensure that they hear back from them in order for the legislation to be realized by the legislature. So having said that, I think that's the enlightened approach. And I think that a former speaker that you had on there, Professor Collins, I believe her name was suggesting to this body that it's best to consult with not only Aboriginal peoples, but other stakeholder groups in order to ensure that there's less problems legally with legislation that this government wishes to pass, or any other government in this country. Thank you.
Thank you. Nothing further? If there's nothing further from committee, Mr. Inge, thank you once again for presenting.
Thank you very much for the opportunity to speak with you.
Thank you.
Have a good evening.
Okay, we're going to do one more presenter, and then we're going to take a small break after that. Next I would like to call to the witness table, please, Mr. Stephen Nita and Mr. Larry Innes, Lutzo Dene First Nation. Presenting on, is Stephen here? Michael, can you just check on a... Yeah. Presenting on Bill 38. Is it cooler out there?
Much more comfortable over here. Oh, yeah.
Okay, getting started. Mr. Nita, are you going to have some introductory comments, and who between the two of you will be doing the PowerPoint?
Oh, probably me.
Okay.
You want to do the PowerPoint?
You sing, I'll dance.
Well, no, you might as well earn your money. He'll do the PowerPoint presentation, I'll do a little bit of introduction performance.
Okay, and then just whenever, Mr. Innes, when you want a slide change, just let us know, and Mr. Ball will change to the next slide. With that, I'll turn it over to you, Mr. Nita.
Thank you very much, Mr. Chairman. Members, I'd like to acknowledge Chief Daryl Marlowe, Sub-Chief Addie Jonason, member of the Advisory Committee for the Thaidhne Nina, Mr. James Marlowe, who has been there since day one in this process. I'd like to acknowledge them. I'd like to also acknowledge some of our partners that have been working with Lusige over the many years. Nature United is here, Ducks Unlimited is here, and we've always had the support of the Dene Nation from day one, so I'd like to acknowledge those that supported LKDFN and the Kecho side table process that is Thaidhne Nina. Mr. Chairman, I'd like to also thank you and the committee members for giving LKDFN the opportunity to present our thoughts on the protected AR legislation. As you know, Lusige has been in the process of working with both levels of Crown, the Big Crown and the Little Crown, as I like to call them, to create the right conditions for Thaidhne Nina. And we've also been participants in the legislative proposal development. So we're here to speak in support of the legislation and to suggest a couple of minor amendments. And I'll hand this over to Mr. Ennis to do the PowerPoint presentation for the committee.
Thank you, Mr. Nita. Over to you, Mr. Innes.
Thank you. And we have on the screen behind you, and hopefully in front of you as well, a PowerPoint to basically help me cover the points that Lutzel Kay wishes to make in respect of the protected areas legislation. So basically the presentation is broken into 4 parts. We'll start by talking about why Lutzel Kay participated in the drafting of the legislation. We'll then turn to how Lutzel Kay participated in the drafting of the legislation. And then we'll provide some specific comments on the bill and some recommendations for the consideration of the committee. So to begin with, Lutzel Kay is here primarily because it had the opportunity to engage with the government of the Northwest Territories, with other Indigenous governments, and with institutions of public government in the development of this legislation. We believe that this reflects a modern approach to framing shared decision-making in the establishment of protected areas, drawing on best experiences and best practices that Lutzel Kay in our research in looking at how protected areas have been established, not just in Canada, but indeed around the world, have succeeded in reflecting the fundamental rights of Indigenous people to determine their own futures on their own lands. And I'll note that the United Nations Declaration on the Rights of Indigenous People speaks in Article 19, to the rights of Indigenous people to participate with legislatures through institutions such as the Lutzel Kay Dene First Nation to provide free, prior, and informed consent to legislative or administrative mechanisms that may affect them. We believe that this bill in large measure accomplishes that. First, by ensuring that legislation introduced to establish protected areas does not have an adverse effect on constitutionally protected Section 35 rights. Also, going beyond that, not having an adverse effect, to actually recognizing and affirming those rights and reflecting the treaty relationship. We believe it properly frames the jurisdictions and authorities of the GNWT in relationship to the jurisdictions and the authorities of Lutzel Kay and other Indigenous governments. And it also, through the mechanisms established in the legislation, ensures that protected areas, once established, have the opportunity to be managed under a shared decision-making framework with participating Indigenous governments and, where applicable, with renewable resource management boards and councils under settled land claims. Finally, we see this as an opportunity for the Northwest Territories to indeed provide a leading model of such legislation, not only for Canada, but also to the world. We looked in the development of this legislation to translating these objectives into specific provisions. And we believe that the bill, in large measure, accomplishes Lutzel Kay's goals. It first and foremost sets up a system of rights recognition, which ensures that Indigenous governments are involved at every step, from nomination through to establishment, in creating new protected areas. It requires the minister to enter into negotiated agreements for the establishment of protected areas. And it requires that once established, these protected areas are managed through collaborative and cooperative governance arrangements with participating Indigenous governments and organizations, and indeed provides scope under the legislation for the development of shared decision-making in the management and the management plans for those areas. So we did this largely in relation to Thaidene. And Thaidene, as most folks in this room know, has been a work in progress for well over 40 years. Some of the benefits associated with Thaidene are summarized here. I won't go through all of them, but suffice it to say that Lutzel Kay has been engaged directly with the government of the Northwest Territories in the negotiation of an establishment agreement for a territorial protected area, which would be adjacent to and indeed intertwined with a federal national park reserve managed under different legislation, but under a harmonious regime in which all activities are subject to Aboriginal and treaty rights, where rights-based activities being undertaken by Indigenous persons within the areas are guaranteed, and where local residents and visitors to the area will be able to use Thaidene much as they do now, but for industrial development, which will be excluded. There will be some provision for access corridors in the territorial protected area. There will be provisions for new infrastructure and new services, both in Litzel Cay and indeed as over the course of time as management plans are developed throughout the protected area. So people who are traveling in the area now will be able to avail of services established to support the park. This will all be done not through consultation, but rather through shared decision-making and shared management. And through this process, Litzel Cay, as a participating government, will be directly involved in the management and in the operations of Thaidene, leading to, by our estimates, 18 positions, including 8 full-time jobs in Litzel Cay. And those of you who know Litzel Cay will know that 8 full-time jobs in a community of about 300 people is a significant benefit. There will also be infrastructure created in Litzel Cay to host visitors, including commitments for over $32 million of federal expenditures over the first 12 years and $3 million a year in ongoing support. The government of the Northwest Territories, as Stephen says, the Little Crown, in this partnership, has fewer means, but it has stepped up and it is contributing, under our agreements, over $290,000 a year to support Thaidene and the operations of the territorial park. So all of these benefits, and indeed all of this work, hinges on timing. We are, as you committee members well know, in an election year. The mandates of your government, the mandates of the federal government, draw to a close very soon. It is Litzel Cay's objective to establish Thaidene in federal and in territorial legislation this summer. We undertook a ratification process in the communities, in Litzel Cay, and in the other communities in which Litzel Cay members live this winter. We received in February an unprecedented show of support from Litzel Cay's members to move forward with establishment this year, with 88% of members voting in support. Canada has introduced Bill C-97, which provides, in part, for the establishment of Litzel Cay under the National Parks Act, makes amendments to that act, and adds Thaidene to Schedule B as a National Park Reserve. These are significant steps, but we're concerned that any delay on the part of the Legislative Assembly in enacting the Protected Areas Act will delay the establishment of the Territorial Protected Area. And this, in turn, can put Litzel Cay's long-term funding and the long-term jobs that are associated with this initiative at risk. All the conditions are right, but the window is closing on this government. This is a timeline showing the steps that have been taken and the steps that need to be taken. The goal of Litzel Cay is to conclude and finalize the establishment agreements with the governments of Canada and the Northwest Territories at a signing ceremony in July of 2019. This will formally and in law create the conditions for the establishment of Thaidene as a federal National Park Reserve, as a territorial protected area, and as an Indigenous protected area. However, we are here, almost the 1st of May, and there are only a few legislative days before July. So we are quite concerned that the committee take our needs into account in the scheduling of your report on this bill, We understand that there is a lot of legislation in front of you. Our modest proposal to the committee is that you take the Protected Areas Act as a priority and try to conclude your report on this piece of legislation, on this bill, perhaps in advance of your reports back to the legislature on other bills, so that this bill can be returned to the Committee of the Whole in May. This will enable us to hit our windows, enable us to celebrate in July of 2019. We recognize that there has been a tremendous amount of work done by all parties in developing this legislation. And we have only a few small proposals with respect to the actual text of the bill for the committee's consideration. The primary recommendation is what we call a transitional provision. Transitional provisions are included to ensure that work done prior to the passage of legislation is counted as being effective under that legislation. We think it's useful for the committee and useful for the legislature as a whole to adopt a transitional provision to ensure that there is no ambiguity on the part of the Legislative Assembly in recognizing Thaidene as a candidate protected area, and no ambiguity that all of the work, including the conclusion of establishment agreements that have been done by Lützelke and the government of the Northwest Territories prior to the passage of the legislation, are considered to be actions taken in accordance with the legislation for the purposes of designating Thaidene as a protected area. We think this could be simple. We think it could be as simple as this. And finally, we also note that there is, in the definitions of the legislation, and this is a point that, again, is to seek consistency between this legislation and other bills before your committee and indeed before the legislature, to ensure that lands, resources, and self-government agreements are defined in a way that recognize that policy has changed. There is no longer just a single track in Canada's rights recognition policies. Lützelke is part of an ACACHO process working towards the recognition of the treaty relationship based on the Treaty of 1900. This may take the form of a comprehensive land claim. It may also take the form of a recognition of rights agreement. We need to ensure that this legislation is broad enough and inclusive enough that a final ACACHO agreement can be recognized as a prescribed legally binding agreement and included within the definition of a lands, resources, and self-government agreement under the Act when such an agreement is made. These would be our comments, and we leave the committee the rest of the time for questions.
Thank you. Thank you very much, Mr. Innes, for your presentation. Very detailed. We respect that, and thank you, Mr. Nita, for your opening comments. This time, committee, questions, any points of clarification from members? Mr. O'Reilly.
Thanks, Mr. Chair. So I can't find the section in the bill, but the minister does have the discretion to allow transportation transmission corridors through an established protected area. And the only requirement seems to be that the minister consult with the management board. Actually, it's Section 36 of the Protected Areas Act. The only thing the minister has to do is consult with the management board for a particular protected area. And this is a notwithstanding clause. It overrides everything else in the Act. Does this give you the sort of comfort and certainty that you need to move forward with Thaidene? Thanks, Mr. Chair.
Thank you, Mr. O'Reilly. Mr. Innes.
We'll answer this in two parts. I'll speak to what the legislation says, and then Stephen will address what we've included in our establishment agreement. So the legislation provides under Section 14.3 a list of subject matters that can be included in an establishment agreement, including provisions addressing transportation corridors. So while the legislation, in our view, provides, yes, a certain ministerial override, it also provides an obligation on the minister to conform to the establishment agreement, which is a legally binding agreement between the minister and a participating Indigenous government. So we're confident that the minister, faced with a decision in respect of a corridor, will first turn to the establishment agreement and address that corridor in the context of that establishment agreement. There are also, and this is not a direct concern for Litzel Kay at the moment, there are also requirements under modern land claims, Chapter 21 of the Sawtooth Agreement, et cetera, that deal with questions of transportation corridors that would also need to be taken into account. So while the bill does provide mechanisms, we think it needs to be read harmoniously with the establishment agreement, with the land claims, and with the regulations before conclusions can be drawn on a particular corridor.
Thank you. Further, Mr. Nita?
Thank you, Mr. Chairman. Mr. Chairman, before I address the question, I also I neglected to acknowledge Councillor Stephanie Poole and two of her daughters that are here to support LKDFN and this legislation. The two daughters are going to be the future ancestors of our people in the community of Litzel Kay and the Northwest Territories. The establishment agreement certainly speaks to transportation corridors and corridors for transmission lines, but those will be allowed only if there is no other alternative. So the proponent of any proposal that speaks to that have to exhaust all other viable options before we could consider the corridor through the Thaidiminiana Territorial Protected Area. The management body that will be created through the establishment agreement, or once they are appointed, they are there to represent the best interests of Thaidiminiana through representing the establishment agreements and also the management plans. Thank you.
Anything further, Mr. O'Reilly?
Thanks, Mr. Chair. Yeah, I understand you guys have a very good establishment agreement, and congratulations. You guys have worked very, very hard towards that, and I appreciate that. The wording, though, Section 36(1), if you look at B, it says that consideration is given to, and then B is any additional requirements set out in the regulations or in any applicable management plan for the area are met. I wonder if you want to stick in the words establishment agreement in there, but I'll just leave that with you folks, or if you want to comment on it. And I congratulate you on getting a great establishment agreement. I also have to worry about the other folks that this is going to apply to and what kind of discretion the minister is going to have to put this sort of corridor through a protected area in the future. But if there's any comments, I'd appreciate it. Thanks, Mr. Chair.
Thank you. To that, Mr. Innes?
Absolutely, and thanks for the question, Member O'Reilly. The way that we expect the establishment agreement to unfold is to be incorporated by reference into the regulations. So that would, in effect, require, it says the minister must consider feasibility of alternatives, et cetera, and then any additional requirements set out in the regulations. So this is where we would directly import the requirements of the establishment agreement.
I would follow up with that.
Okay, thank you. Further, Mr. Nita?
Thank you, Mr. Chairman. Another real good reason why we encourage the committee to bring this legislation back for third reading in early in your session in May. The quicker we get this legislation into law, the quicker we can start developing those regulations, because we need regulations to enact the Thaidiminiana in the Territorial Protected Area legislation. So we still need that window after the protected area becomes a legal instrument. That's another reason for our strong recommendation to this committee that you move the protected area legislation on its own, if necessary, into law.
Thank you. Next, I have Mr. Tester.
Thank you, Mr. Chair. I've been eager to have this conversation with you, given the nature of the park, and I'm glad we're able to talk about this tonight. With respect to the transmission lines, I mean, my concern was around, you know, the integrity of that protected area, and leaving things up to regulation when there's kind of those broad provisions was a bit troubling for me. But the information you shared about the establishment agreement underpinning that power is helpful for my understanding. But it leads me back to an earlier observation I had reviewing the legislation, which is, as you mentioned in your presentation, the federal legislation works very different, where parks or protected areas are established as schedules in kind of the overarching legislation. And there is a legislative process around that. I guess my concern is, notwithstanding that the GWT has entered into a very meaningful relationship in the co-drafting process, and I think it is a good model, but our role is not part of that process. It's part of the public legislative process as representatives of our constituents and the broader public at large. What if the legislation was contemplated to, you know, take an establishment agreement after it's been sorted out and then enshrine it in law as kind of a separate statute, like a tied in a Park Act that attaches itself to the overall Protected Areas Act. That way, some of the concerns that members have had around, well, how does it really work? We have to wait for regulations. It's pretty clear. It's very clear how this particular park or particular protected area is going to work, and there's absolute legal certainty, and it's not up to the government just to write regulations, because those regulations can change. And I know there's some limitations to how much they can change, but ultimately this committee nor MLAs get to see that process. So my question would be, if the bill was amended to allow that, to bring establishment agreements forward in very concrete statute, do you see that as achieving some more certainty, or do you have any problems with it? Let's just put it that way.
Thank you. To that, Mr. Innes.
And thanks, Member Testart, for the question. I would say there's probably less daylight between the federal approach and the GNWT's approach here than you might think. The way that, and I'll just talk briefly about how it works under the Federal National Parks Act, is that the addition of a new national park to the legislation is primarily the addition of the description of the area to the schedule of the Act. There's not typically a new piece of legislation associated with it. There are occasionally particular consequential amendments to Section 40 of the Federal Act, which provide for the unique features, if you will, of a particular park, but it tends to be a couple of clauses as opposed to a self-contained piece of legislation. The way that establishment agreements are incorporated federally is under Section 10.1 of that legislation, which is actually a lot briefer and a lot thinner than the rather robust list that we've developed through the co-drafting process for the territorial legislation. So I would say, you know, if I was advising my clients, which piece of legislation would you rather use to accomplish your goals? The territorial legislation is far more modern in its structure, and it's far more inclusive of Indigenous governments as co-developers of protected areas, as opposed to the federal legislation, which, you know, let's be frank, it dates from a different era, where the minister, you know, by her good grace, enters into these agreements, but doesn't have to do so on the direction of the legislature. So I think that there is considerable merit to the approach the government of the Northwest Territories with its Indigenous government partners has taken on the issue of including that establishment agreement as a standalone piece of legislation. I would be concerned that one of the key parties to those establishment agreements, the Indigenous government, would then have to petition the legislature to make changes to that establishment agreement. And that would seem to be a little self-defeating if the intent is to engage on a government-to-government basis through intergovernmental agreements. So I think having the establishment agreement between the parties provides actually a more equal standing and is a more equitable and more appropriate framing of the relationship between governments.
Thank you. Anything further, Mr. Testart? If there's nothing further from committee, I want to thank Lutzel K'e Dene First Nation for coming and presenting today, and the members of the community, all of you, for coming and supporting. It's very much appreciated. And at this time, we will take a break so that everyone can come and stand with me over by this fan. Let's resume here. Let's make our best effort to resume here in about 5-7 minutes. All right? Thank you. All right, thank you, everybody. We can reconvene our meeting, and thank you for bearing with us, and appreciate that this room, when it gets full, can get a little bit warm, and so we've done our best here to get some doors open, get some fans on, and try to keep it cool. We have lost, a few members now have left, so we can hopefully cool the room down a little bit, and I know how Sunny knows how to cool down a room, so without further ado, we have Ducks Unlimited Canada presenting on Bill 38. I believe we have here this evening with us Sunny Lenore and Kevin Smith. And as far as I'm aware, we are just going through speaking notes. We don't have a presentation deck, is that correct? So I'll turn it over maybe to Kevin or Mr. Smith to get us started. Maybe introduce yourselves, and turn it over to you. Thank you.
Thank you, Mr. Chairman, and thank you, members of the Standing Committee, for having us to speak on Bill 38 tonight. My name is Kevin Smith, and I'm the National Manager of Boreal Programs with Ducks Unlimited Canada. And to my left is my co-conspirator here in the Northwest Territories, Sunny Lenore. We're very grateful for the opportunity to speak today on Bill 38, the Protected Areas Act. We did have some additional messaging on Bill 39 and Bill 44, which we have submitted. We also have some speaking notes, which we'll share with the committee as well. But in interest of time, we're just going to talk about Bill 38. Early on in our Boreal program, we recognized the importance of the Northwest Territories to wetlands, waterfowl, and opportunities for conservation. Nearly 1/3 of the breeding waterfowl in the boreal forest come from the Northwest Territories. And as an organization, we are science-based, partnership-oriented, collaborative, and we believe that through creative, collaborative conservation solutions, we can have healthy northern communities, healthy northern economies, and also a healthy environment. I'll turn it over to Sunny Lenore.
Thank you. Sunny, over to you.
Yeah, Masi Cho, Mr. Chair. We're very proud to have worked approximately 30 years in the Northwest Territories here. And we continue to focus on this important area of our work into the future. We're investing between $500,000 to $750,000 a year in projects in NWT that are directly benefit the NWT economy. And we have leveraged and we are brokering to access additional funds to support land use planning, research, and other sustainable development activities. The NWT is blessed with some phenomenal wetland complexes, and Bill 38 and other pending legislative reviews will be instrumental in protecting, conserving, and sustainably managing them for generations to come. Ducks Unlimited Canada is uniquely positioned to assist with these very important processes. We have worked collaboratively with other governments and national organizations across Canada in developing policies and strategies in this regard, and are pleased to contribute our expertise and our perspectives to the GNWT legislative review process today, in particular to Bill 38. Now, Ducks Unlimited Canada supports Bill 38, and we offer the following general comments. As provided in the introduction of the bill, Ducks Unlimited Canada supports the legislation's recognition and respect to Aboriginal treaty rights of Indigenous peoples. The strong recognition in this act of the leadership and important role that the Indigenous peoples bring to conservation provides a unique connection to simultaneously achieving conservation responsibilities under devolution as well as reconciliation. We have previously applauded the GNWT for its leadership to balance and update various national resource acts concurrently. Doing so can help lead to more transparent and predictable regulatory regimes that will attract investment, stimulate economic development, and meet numerous economic, environmental, social, cultural needs of the people of the NWT. This new legislation is arguably overdue, and in our view, is fundamentally required to broaden and diversify opportunities in the NWT to help enable conservation economy. The protected areas legislation is critical to ratify decades of hard work related to the ADAGI and to identify protected areas, and to help unleash the potential of these and other areas hold for recognizing local objectives and opportunities. This act will help protect our valuable wetland ecosystems that are so integral to the land, the life and livelihood of everybody in NWT. With the North being so particularly sensitive to the impacts of climate change, the NWT must lead by example in developing strong strategies and legislation like this one to support the protection of our vast reservoirs of carbon and wetlands and other natural ecosystems. As noted in the introduction of the bill, Ducks Unlimited Canada agrees that climate change considerations must be factored into this protected areas planning and management. As Ducks Unlimited Canada has articulated in previous submissions, wetlands play a crucial role in securing vast stores of carbon in the protection of wetland ecosystems and provide significant climate change mitigation and adaptation benefits. Ducks Unlimited Canada has recently provided a professional paper to the Department of Environment and Natural Resources, which explores the current state of knowledge related to the wetlands and their complex linkages to permafrost, carbon cycling, and climate change in northern Canada. And we know that's happening right now. We'd be glad to share these science-based papers with the committee if needed. I'll turn it back to Mike.
Thank you. Mr. Smith?
Thank you, Mr. Chairman. In our view, the Protected Areas Act is the highest priority among the 5 ENR legislations being considered by the GNWT. We strongly support the messaging of our 2 previous partners, Steve Nita and Larry Innes, and also the Chief Marlowe and the community of Little Cay in enacting the legislation in a timely manner with the timeline set by them. Ducks Unlimited supports that completely. Conserving wetlands and habitats across our great land mass is a challenge, and this legislation is one very important and required tool for a made in the NWT comprehensive and balanced approach for managing lands and resources. DUC also encourages the legislature to move swiftly on progress related to the Waters Act to ensure that objectives like wetland protection, conservation, and sustainable development are appropriately captured in that legislation as well going into the future. There's much work to be done to address the underlying conditions that cumulatively impact the well-being of northern people and communities. Investing in these northern people and communities and regions while developing new and improving environmental policies will help address all of the conservation goals of northern people together. Indigenous-led actions with the support of government and other partners will play an important role in successful efforts to enhance health, economy, languages, and cultures across the North. Leveraging responsible government policies to drive awareness, skills development, and possible employment opportunities in a conservation economy will be crucial components to building this strong North. Further, addressing environmental health and wellness-related issues such as wetland conservation, protection of areas, and sustainable land use will be essential. This bill will certainly help address many of those challenges. In summary, the NWT has a tremendous opportunity to advance conservation through this bill and other legislative reviews to ensure abundant wetlands throughout the Northwest Territory continue to provide benefits for future generations. So once again, we strongly support and endorse this bill, encourage its passage, proclamation, and implementation. We appreciate the opportunity to provide input and would look to continue to provide input as you develop this through the regulatory process. Thank you for your time today, and we welcome any questions.
Thank you. Thank you, Mr. Smith, and thank you, Mr. Lenoir, for presenting to us today on Bill 38 on behalf of Ducks Unlimited Canada. I also would note that, Mr. Lenoir, you did mention some information additional information or reports of something of that nature that you'd be willing to share. We absolutely would be willing to accept those, so you can certainly send them to our clerk. That would be appreciated.
No problem.
Thank you. Comments, questions, clarification from committee? I have Mr. Testart.
Thank you, Mr. Chair. Thank you very much for the presentation. We've discussed these issues before some time ago, and I think we all expected this legislation to move forward quicker than it did, but here we are. So you mentioned that one of the areas of the bill that you feel works well is the strong recognition of Indigenous rights, self-governance, and the co-management system we've had in place for quite some time. With some of the comments we've heard from Indigenous governments presenting to the committee on Bill 38 is a desire for stronger recognition of the co-management bodies that are set up by treaties in the Act. Do you have any perspective on that? Do you think the bill adequately addresses the co-management systems that are present in the Northwest Territories, or if additional specificity to those agreements would further strengthen the legislation? And it's fine if you don't have a position on it. I'm just curious. Thank you.
Thank you. Who would care to answer? Mr. Lenore.
I believe actually it would actually strengthen if this co-management board had a better strength to regulate their own land. I mean, they're the players of their own land. They already see it. They've been on it every day. Some of them all day, so they know what's going on. And some of those people that work on those management boards in those regions actually they're on the land people. They're the eyes and ears as well. So I believe actually the strength would be more into the regions.
Thank you. Further, Mr. Testart?
Thank you for that. Turning to climate change, you've presented. I've seen some. I think I've seen the papers you've spoken of around the tremendous potential that the boreal carbon sinks have. Do you feel that the bill adequately addresses climate change? Obviously, it does in a roundabout way. If you preserve that land, it has other benefits. But do you feel that there's adequate consideration of climate change policies and frameworks in how candidate areas are selected and how the regulations will be written, all that kind of stuff? Do you feel climate change is properly given the attention it deserves in Bill 38? Thank you.
Mr. Smith.
Yeah, thank you, Member Tester. Yeah, I think that there is an opportunity to advance the climate change in response to it in all five bills. And I think there's more that can be done. Obviously, there's a lot of uncertainty around climate change, but one thing that is certain is that it's changing faster here in the north than other areas. So understanding some of that certainty and decreasing that knowledge gap is what we're here to support with, and that was the paper that we will submit that has a lot of those scientific review of the state of that you can look at and help with that process. So,
thank you. Nothing further, Mr. O'Reilly.
Thanks, Mr. Chair. Yeah, I don't think we've received your written submissions yet, so I haven't had a chance to look at them. But are there any specific amendments or changes that you want to highlight in any of the three bills for us this evening? Thanks, Mr. Chair.
Thank you. Mr.
Yes.
Smith.
Thank you, Mr. Chair. We support Section 14.1 that indicates prior to a candidate protected area being established as a protected area, the minister must enter into establishment agreement and so forth. But having said that, there's terminology in there such as best efforts and irreconcilable differences, such as under Section 14.4 and 15.2. that appear to remain subjective to interpretation. So I think perhaps supporting principles, definitions, or criteria to assist consistent application of those terminologies should be considered under further regulations or potentially policy guidelines. That was one of the kind of specific things. Also, we agree that management plans should be completed as soon as practical, and we very much support the provision under Section 25 to allow for interim management guidelines to be enabled. Also, under Section 36.1 in Part 4, allowance for and corresponding conditions are stipulated for granting access to land in a protected area for transportation and transmission corridors. DUC supports those as well, but we recommend that mitigation requirements be considered as part of supplementary regulations, guiding policy, or perhaps entrenched as an integral component of the pending Waters Act.
Thank you. Think further? If there's nothing further from committee, I want to thank Dux again for presenting. Very much appreciated. Okay, next to our witness table, I'll have Mr. Hadley Archer, Executive Director of Nature United, speaking on presenting on Bill 38, and Tracy Williams can join as well. And if you just and there's no deck, there'll be speaking notes only, and I'll start with you, Mr. Archer. Over to you.
Thank you, Mr. Chair. Good evening, everyone. I'd like to open by acknowledging that we're on Chief Dragi's territory, traditional home of the Yellowknives Dene. Mr. Chair, members of the Standing Committee on Economic Development and the Environment, thank you for the opportunity to speak to you this evening. As mentioned, my name is Hadley Archer. I'm the Executive Director of Nature United, and I'm joined by my colleague Tracy Williams, who's based here in Yellowknife and leads our work in the Northwest Territories. We're honored to be in here in person to offer our strong support for the work of the Government of the Northwest Territories and the work you've done in creating the Territories' first Protected Areas Act, Bill 38. Nature United is dedicated to conserving nature as the foundation of strong communities, a prosperous economy, and a future worth passing on to our grandchildren. We work in partnership with Indigenous peoples, industry, and government in 3 priority geographies in Canada: coastal British Columbia, northern Manitoba, and here in NWT. Our approach is to support local leadership, bolster local and regional economies, and improve community well-being. We believe sustainable economic development and conservation must go hand in hand. In the Great Bear Rainforest, for example, where we've worked for nearly 15 years, we continue to build on the success of a public-private investment of $77 million into Indigenous stewardship and local sustainable economic development. Over the last decade, that investment has leveraged an additional $190 million, creating more than 1,000 new jobs and creating or expanding 100 businesses. As the Canadian affiliate of the Nature Conservancy, a global organization working in 72 countries, we've also worked with protected areas legislation around the world. We have contributed to the Northwest Territories' efforts to create a network of protected areas, beginning with the Protected Areas Strategy over a decade ago. Bill 38 is the next step in implementing the GNWT's Healthy Land, Healthy Peoples Conservation Network Planning Strategy. The Act will allow Canada protected areas, identified and championed by communities and the GNWT, to be fully and permanently protected. We commend the GNWT for this Made in the North legislation. We believe that Bill 38 sets a national standard for how Canada can achieve its international protection commitments in a way that respects the rights of Indigenous people, honors the recommendation of the federal government's Target 1 National Advisory Panel and the Indigenous Circle of Experts, and demonstrates how legislation and land stewardship can and must be done in partnership with Indigenous peoples. Tonight I will offer a few observations as the basis for Nature United's support for Bill 38, which we believe provides the foundation for protecting ecological and cultural integrity of Canada's North and for new sustainable economic development. Simply put, we will ask the Standing Committee to recommend to the Committee of the Whole the passage of the legislation during the upcoming spring session. From Nature United's perspective, protected areas legislation, such as Bill 38, must meet 3 key criteria in order to be comprehensive, durable, and effective. Firstly, a Protected Areas Act should protect the long-term ecological integrity, diversity, and resilience of an area by managing all uses, ensuring consistency with Indigenous cultural considerations, and representing the diversity of a region's ecosystems. Bill 38 achieves this by asserting permitted activities in protected areas cannot substantially alter biodiversity, ecological integrity, or cultural continuity. Prohibited activities are clearly outlined, as are enforcements and penalties. The network of protected areas created by the Act is intended to be permanent and changing protection requires agreement of both the GNWT and Indigenous governments. Secondly, a Protected Areas Act should provide directly for modern contractual mechanisms by which Indigenous peoples and local communities can create the terms for shared management and decision-making. This is particularly important to Nature United. At the heart of our approach to conservation is respecting the rights of Indigenous peoples, and we support Indigenous leadership and authority to manage lands and waters. We commend the GNWT for its 2 years of work with Indigenous governmental organizations in the creation of this legislation. The specific criterion is fulfilled in the Act by the use of establishment agreements, which serve as contracts between Indigenous governments and the GNWT. Prohibited activities agreed upon in the EAs will be incorporated into law when a protected area is established. Thirdly, a protected area should contribute to local economies through tourism and other commercial ventures that would positively benefit Indigenous-led and other place-based conservation initiatives. We have been an important partner in diversifying local economies in other Canadian geographies and around the world through conservation, land management, tourism, and other commercial ventures. We also support the development of Indigenous Guardian programs as a fundamental means of economic diversification connected to conservation. An independent analysis of Indigenous Guardian programs has shown a financial return on investment of more than 10 to 1, in addition to substantial community and cultural benefits. We have observed firsthand the powerful economic benefits that can come from conservation, but those benefits depend on a strong legal foundation that provides certainty for rights holders and investors over the long term. The NWT Protected Areas Act meets the criterion by providing certainty and transparency to the public, including industries and others who seek to invest in the NWT. At the same time, it provides a catalyst for new diversified economic activity surrounding protected areas. An economy that builds upon the ever-increasing tourism that is already bringing more than $200 million annually to the region. To summarize, based on these three criteria, permanent protection of ecological integrity, integrated mechanisms for shared management with Indigenous governments, and certainty that fosters local economic benefit, our perspective is that Bill 38 is a robust Protected Areas Act that can provide the legal foundation for conservation and economic diversification. As a longtime partner of the Lhotsokay Dene First Nation, Nature United has provided technical support, science expertise, financial support, and support for longer-term sustainable financing for ongoing stewardship of Thaida and Nene. We commend ENR and the ENR Ministry for leading a rigorous effort to co-produce the Protected Areas Act with its Indigenous government counterparts, which resulted in the legislation we see today. We support the SCEDI Committee's thoughtful deliberation of this bill, and it is our hope that the committee finds Bill 38 to be worthy of advancing for passage during the spring session, so that it may be used to create new protected areas before the end of this government's mandate and the fall election. In closing, we believe the bill will protect ecologically important landscapes in the Northwest Territories, safeguard cultural connections to the land, uphold Indigenous rights, diversify the economy, and provide significant benefits to future generations amid a changing northern and global climate. It will be an important step towards a Canada where we value cultural, social, and ecological values of our landscapes, and where we work to create a truly diversified, sustainable economy for people and nature. Thank you for the opportunity to present to the committee this evening.
Thank you. Thank you very much, Mr. Archer, and of course, Ms. Williams for being here on behalf of Nature United and presenting on Bill 38 this evening. Your comments are very much appreciated, and we would very much appreciate getting a copy of your speaking notes, and if you wouldn't mind, if you, either this copy or an electronic version, you can share with our clerk, Mr. Michael Ball. At this point, I'll turn it over to committee for any questions or need of clarification. Any questions from committee? Mr. O'Reilly.
Thanks, Mr. Chair, and thanks for the presentation. Are there any specific amendments that you folks are recommending to Bill 38 in particular? Thanks, Mr. Chair.
Thank you. Mr. Archer.
Thanks, Mr. Chair, and Member O'Reilly for that question. We would support the proposed amendments that Lhotsokay presented earlier, and essentially in a way to expedite the process for creating, concluding the legislation and enacting it. So no, beyond that, no additional amendments that we would recommend.
Thank you. Further, Mr. O'Reilly.
Yeah, thanks, Mr. Chair. So just quickly, do you work with other communities beyond Little K? And if so, is there anything in here that you would recommend be changed? Because this is not just for Little K, this is for the Northwest Territories. Thanks, Mr. Chair.
Thank you. Mr. Archer?
No, great question. Thank you, Member Riley. No, we've reviewed this from a territory-wide perspective and against the criteria that I mentioned or that I described earlier, and based on that, we would not propose any additional recommendations. We think that the legislation as drafted is sufficient and will meet its intended purpose, along with the regulations and establishment agreements that will accompany it.
Thank you. Nothing further. Next up, Mr. Testart.
Thank you. So, thank you for your presentations. One of the criteria you laid out was the permanent protection of a conserved area. Now, my understanding of this bill, it does allow the minister, in consultation with an impacted Indigenous community, to alter the boundaries of a protected area through regulation. Do you see a concern around that, given that, that can be a kind of sidebar discussion that's had, the boundaries can be changed, it doesn't come back to the Legislative Assembly for ratification, verification, public comment, anything like that. It's a relationship that's certainly a co-management relationship, but it doesn't necessarily create that permanency that you've laid out as a criteria. Thank you.
Thank you. Mr. Archer? Ms. Williams?
Just to add to the chair's understanding, we will have a written submission as well. So we can provide the comments that we've made tonight, but in addition, there'll be written submission by Friday. With answering your question, I think the best way that we have been able to view this question when we've asked it of ourselves is that the contractual mechanism will allow for the groups that are going to be negotiating that to wholeheartedly look at a case-by-case basis at what is going to be necessary for the planning and the management of that area. And so many of the things that would be salient or relevant to an area regarding the types of changes that might be made should be done so at that time. And so I think that the mechanism of an establishment agreement actually allows for a fulsome understanding of the types of things that will be needing to be provided for in that actual mechanism.
Thank you, Ms. Williams. Anything further, Mr. Testart?
Thank you. So you've obviously been very close to the development of some of these discussions and are informed on them. But so I'm wondering, like, your understanding is you wouldn't see something like the boundaries pulled back to make space for a mine or a hydroelectric dam or some other large industrial feature that might have an economic incentive to the impacted region and the impacted First Nation, but require a boundary to change. And that might be in the interest of both the economic interests of both of the Indigenous nation and the government of the Northwest Territories. But your understanding is the establishment agreement would shield against that kind of change?
Thank you. Ms. Williams?
There's lots of hypotheticals that could exist, and that people will have to real scenarios that will have to be considered in a case-by-case basis for each individual candidate protected area. Having said that, there are numerous laws, not just this particular law, that will that these particular projects could and will have to be subject to. And with each of those laws, there is a number of different checks and balances that will have to go on. with meeting the requirements of those laws. So that taken in along with the Protected Areas Act itself, the establishment agreement, any land and resource agreements that this would be subject to, including the management board, decision-making body. There's a whole host of various checks and balances. So it will not be just a stroke of a pen to make these things real.
Thank you. Further, Mr. Testart.
So you mentioned the Great Bear Rainforest as kind of a proven model of conservation economy. The underpinnings of that protected area are, given all the other questions I asked, like do you feel that the Bill 38 provides the same kind of conservation basis for the level of investment you've seen in the Great Bear? Thank you.
Thank you. Mr. Archer.
Thank you, Mr. Chair. We've evaluated the proposed legislation against Federal Parks Act and against BC Parks Act, and have concluded that it does have the key components. I think probably the most important one is around co-management and shared decision-making. As I mentioned in my remarks, that provides the basis for Indigenous communities to build a conservation economy and for investors to invest in that. And really that's what's, and for those communities to be the effective stewards and managers of the lands. So we've really seen that has been the foundation for attracting that investment that I mentioned in my remarks. And if it were not there, I mean, that in that particular case, it's a very diversified economy with many different economic avenues being pursued by different nations. But fundamental to that is an underpinning around ecotourism, and that's incredibly important for not just the nations, but for the whole region, to make sure that there are that shared decision-making framework is in place.
Thank you. Nothing further. Mr. O'Reilly?
Thanks, Mr. Chair. So I know that you folks have been directly engaged and involved with Litzel K and creation of Thai-Dene Nene. There is provision in the Protected Areas Bill for the Minister to ensure there's Section 16.1. The Minister shall ensure there's an opportunity for public engagement as the Minister considers appropriate before the establishment of a protected area. So there's to be a role for the public in the establishment of a protected area. But when it comes to putting a transportation corridor through a protected area, there's no requirement for any public consultation. The Minister just has to consult with the management board. Is that something you folks think is best practice? Thanks, Mr. Chair.
Thank you. Any comment? Ms. Williams.
We can elaborate on the corridor issue on a case-by-case basis as the public through a variety of mechanisms or a variety of different channels. A corridor would require a project in order to make that particular corridor useful and meaningful to the people of the Northwest Territories. Through that project, there will be many different checks and balances in addition to the establishment agreement or any other agreements that are beholden to the Protected Areas Act candidate area or the EA. And so with those variety of checks and balances, including the actual executive, we think that there is sufficiency in this bill to allow it to go forward.
Thank you. Nothing further, Mr. O'Reilly. Thank you both once again for presenting on behalf of Nature United on Bill 38. Thank you. And just a reminder again, if we can get your comments, written version, it'd be greatly appreciated. Appreciate that. Thank you. Okay, just so folks know the order, next I have Nancy Vale will be speaking on Bill 39, and then I'll have Sarah Brown, Norman Yakalaya, Nick Leeson, Matilda Becker, and Zoe, sorry? Gaia? Guile. Sorry for the poor pronunciation. So that's kind of our order. Now, just so folks know, what we're going to do is we'll get a sense of the crowd at 9 o'clock and see where we're at. If there is a need to go beyond and a willingness, we're certainly open to that. If we have to move to another evening, whoever those presenters are who haven't spoken yet, we're more than happy to meet with you and come up with an arrangement where we can have you present. So, in the meantime, Nancy, I'll turn it over to you if you'd kindly come up to the witness table.
Thanks a lot for hanging in there, by the way. That's greatly appreciated, and to hear us in our concerns and comments. And I will be speaking specifically about the ERA, although a lot of what I have to say can be applied to the other acts coming up for review. I've been a long-term member of Alternatives North, as well as a volunteer and supporter of Ecology North for many years, so I feel that my job is to speak for the environment, which does not have a strong voice within itself. So that's why I'm here tonight. Some of the concerns that I will be presenting come from those groups. Others come from myself. So to begin, and I'm sorry that I have to read. I have so much that I wanted to say, and this is my chance, and I didn't want to lose that. So it is written down, and I will send a copy of this to you by the end of the week. I made a few changes, so I will do that. And again, thank you for being here and letting us speak. I appreciate that. So to begin, I'd like to talk about age limits on those who want to pursue investigative action. Around the world, we are seeing more and more young people hit the streets, airing their concerns about climate change and demanding action from their elected representatives. The actions were spearheaded in part by Ms. Greta Thunberg, a 16-year-old Swedish resident who I'm sure did not require the permission of her parents to approach Swedish politicians, the UN General Assembly, and to enjoy mentorship from Jane Goodall within the last couple months. Last week alone, she made a presentation to the Swedish Parliament in which she reiterated her statement to politicians there that, "I want you to act like our house is on fire, because it is." She was also one of the keynote speakers at the massive week-long demonstration in London last week, Earth Week. This voice has raised the interest of young people around the world, motivating them to march with or without parents. There's supposed to be demonstrations across Canada this Friday, following Europe's lead and including here in Yellowknife, orchestrated by youth and supported by any adults who care to show support. And 2 weeks ago, young people took to the streets in Inuvik with a call to action. I think we're seeing the tip of an iceberg here, with many of these actions being instigated by those most affected by climate change activities, i.e. the young, who are fighting for their very survival. As well, here in Yellowknife, there is an initiative underway to encourage young people to become more involved in vocalizing their concerns about climate change through demonstrations, pursuing safe rehabilitative practices, information dissemination among their peers, and booths at markets where they can gather to exchange ideas to solidify and encourage their activities. Behind this encouragement is the realization that many of them are slipping into despair because they feel hopeless in light of rapid acceleration in climate change impacts. Severe depression, anxiety, and even potential suicide is what our youth are now dealing with. I believe that mental health professionals will be very busy in the next short while trying to help them deal with their anxiety and fears. They call it eco-anxiety, and the paper covered it well recently with information from our local Dr. Courtney Howard. A couple weeks ago, a friend had to pull out of these discussions because her own daughter was slipping into depression. She could not cope with the images she saw on TV or what she heard on the radio. So this issue is on our doorstep. We must empower our young by allowing them ease of access to their government officials and by not stilling their voices. The government, through inclusive actions in bills such as these, and by lowering the age limit, would show their concern, support, and encouragement. No one is too young to contribute to the discussion or take actions that need to be taken. Further, if any of you were listening to CBC, The Current in December, and again last Monday, youngsters from across Canada, as young as 12, were expressing their opinion and knowledge about climate change in ways that are far superior to some of the statements that we hear coming from our politicians. In this amendment, there are conflicting suggestions about who can launch investigations, which on a broader scale includes who can have access to MLAs and cabinet ministers with their concerns, yet these same people must welcome them when the young residents come knocking on their doors. In the preamble, it states, whereas the government of the Northwest Territories and residents of the Northwest Territories have a shared responsibility and goal to ensure the wise management of the environment on behalf of present and future generations, and whereas it is fitting that this relationship be recognized by the government of the Northwest Territories in an enactment in which rights in respects are established and means for protection of the environment are given to all persons to provide residents of the Northwest Territories with tools to contribute to ensuring the government of the Northwest Territories protect their rights to a healthy environment. So with that in mind, there are no guidelines around the age limits of those wanting to participate. It was wonderful, by the way, to see Stephanie here with her 2 daughters tonight. I thought that was great. And I think we're going to see a whole lot more of that in the very near future. So, with that in mind, there are no guidelines around age limits of those wanting to participate in this process, except to use the term adult, which by definition excludes or sets limits and constraints on young people here who want to contribute to the conversation through their voices and their actions. I believe that the last thing they need right now is to be told they are too young to participate or are refused meetings with ministers or the Premier without the consent of parents or caretakers, when in fact their lives are at stake at this delicate times in our lives. Our goal then needs to be one of empowerment, which leads to hope and in turn leads to change. I think the government needs to include this type of inclusivity from a wide spectrum of NWT residents, old and young alike. Further, politicians were not elected to just take care of this, the immediate future, but the future of those who are supposed to be coming after us. I'm asking that you give them a voice and that you include them in this document, thereby showing that we are concerned about their well-being as well. Section 8.1 says, any adult in the Northwest Territories who believes on reasonable grounds that an act or omission has occurred that has caused or is likely to cause significant harm to the environment may apply to the minister for an investigation. Further, Section 13.1 reads, subject to subsection 3, every adult resident in the Northwest Territories has the right to protect the environment and the public trust by commencing an action in the Supreme Court against any person for any act or omission that the resident believes on reasonable grounds has caused or is likely to cause significant harm to the environment. I would like to see both of these broadened to make allowances for the voices of the young. And frankly, I, like most, have trouble trusting some of our politicians and their judgments on some of these issues. Their scope is too narrow, and focusing on business agendas rather than environmental concerns, they often conveniently overlook the voices of those ringing alarm bells about the real state of the environment, where the sky is literally falling in. Access to the minister then needs to be changed to include our young, since many have a better and more realistic sense of what's going on this beleaguered planet. And equally important, the young have to live with the consequences. We will be gone, not them. Maybe we have a Greta Thunberg under our noses and don't even know it. This summer, and likely sooner, we can expect to see more actions. Again, we need to ensure the rights to initiate actions and meet with ministers extended to young people as young as 16 minimum, although frankly, I'm not comfortable with those age limits. On that note, I would like to draw attention to Section 9.3, which states, nothing in this section requires the minister to conduct or continue an investigation in respect of an act or omission alleged in an application under Section 8 if the minister considers that, A, the application is frivolous or vexatious, B, the alleged act or omission is not serious enough to warrant an investigation, or C, the alleged act or omission is not likely to cause significant harm to the environment. I'm not comfortable with that much discretion being given to the minister. I know that might rub some people the wrong way, but I tend to hang out around environmental folks who I believe have a better finger on the pulse of the planet, and in fact what our future holds if we do not act now. Scientists have been saying for years that we are in serious trouble, and we just continue to ignore the alarm bells. Last week and now, floods are ravaging 3 provinces, and fires have already broken out in 2, Saskatchewan and BC, where flare-ups in BC came from fires last year. This year's fire season hasn't started, and we know that each year is being recorded as the hottest on record. We are nothing without a healthy planet, yet many politicians still think that stimulating the economy while ignoring environmental needs will somehow save us. It won't. Only concrete action aimed at reducing the effects of climate change will. On that note, I know that there have been problems with people from the environmental sector gaining access to certain ministers' offices, while people interested in development have a much easier time of it. In fact, they seem to just walk in and there is no to little information about what is happening behind closed doors. My information is that some people from the environmental arena are told that they will be seen when there is an opening or when the minister is available, which could be weeks or much longer, whereas people who have a particular development plan in mind have no waiting time at all. Again, there is little or no transparency about what is happening here in some cases, and no mechanism in place to demand transparency until an idea spawned in a backroom chat has gone from an idea into something much more substantial without any input from the public, who may be more aware of the environmental impacts from other MLAs and from the public generally. I'm very concerned about the monitoring of what happens in those early discussions and inclusivity. Governments are not supposed to be and cannot afford to be an old boys network anymore because there's just too much at stake. So my question is, what can be done to ensure equal and timely access to the ministers by all parties involved, and not favoritism depending on the individual bent of the minister? It is all perspective and subjective after all. I'm sure that the comings and goings of people into their offices are all documented, and if not, I would like to see that done. Further, I would like to see some kind of record kept which shows when requests to meet with the ministers come in and the outcome of those requests and the timelines in which access is made available. I know that environmental types are many times turned away because their concerns are considered frivolous or vexatious. Yet I consider the discussions of some of those pursuing developmental agendas as downright destructive. How can we monitor these discussions and activities so that other elected officials and the public know what's going on from point A? Do we need a third objective party included in all of these discussions so that we don't find out about the direction the minister has been taking until it comes out in a public meeting? Indeed, the point here is that transparency at the outset could eliminate the need for investigative action further down the line, or even at all. How can this be embedded in this document? With all of that said, I took a look at the NWT Climate Change Strategy Framework, which is indeed inclusive of everyone and all age groups. It really is an impressive document. With such a great focus on climate change and its inevitable impacts, which are taking place as we speak, it is hard to understand why the phrase climate change is mentioned just once in the ERA. It reads, 13D, identify links between changes in the environment and causal factors such as development activity, climate change, and natural wildlife population trends. I don't understand this. Climate change and its impacts, how to mitigate damages, prepare for the impacts, and pursue immediate rehabilitative activity should be mentioned throughout, not just once. Climate change must become part of our everyday language and dialogue if it is going to receive the concern it merits. It can no longer be an afterthought or a polite inclusion. This hearing, as we all know, occurred both during Earth Week and this week, the week after. And I am sure that is on all of our minds as we learn more about what it's going to cost to rebuild infrastructure in Tuktoyaktuk, for example, which is quickly disappearing into the water, and as our caribou are disappearing. One herd alone going from 146,000 in the mid-'80s to 8,000 now, and dropping again by half every year. Both of these phenomena are the result of developmental practices of the past. It is just the start of what's to come, yet preparing for the skyrocketing costs of infrastructure rebuilding and protecting our wildlife are not touched on in this document. What I'm suggesting then is that the phrase climate change should not just be two words slipped into one paragraph, but indeed should be the mainstay of any document under which everything else covered should adhere to. Protecting the environment then should be the umbrella. In fact, I do not understand why climate change strategic planning does not have a department of its own, which now I know has actually been discussed, operating at arm's length from the government, since the government too often puts developmental needs ahead of environmental protection. That's backwards. Flipping this would show the public that the government is taking the issue and their lives seriously. Let's not forget that there are some environmental types, such as Bill McGibbon at 350.org, that says it's too late. The only thing we can do now is prepare for how we are going to withstand impacts. In fact, scientists are now saying the planet is not only in climate change-related distress, but that we have 11 years before we slip into climate change disaster. We needed to take this situation seriously 30 years ago, but we didn't. So I think we need to get on this now. I know that parts of this are beyond the scope of this committee, but I believe you can do something. We can begin by addressing the climate change issue more often and thoroughly in these documents, with entire clauses devoting to mitigating impacts. If we have an organization in Yellowknife that actually brings in a speaker suggesting that climate change is not happening and espousing conspiracy theories that make no sense when we can witness impacts all around us, there's obviously a disconnect between people pursuing business objectives and reality. Each development proposal, no matter how small, must be examined by all parties thoroughly, because one small change plus one small change plus one more small change can equal planetary disaster. The little home of ours cannot cope anymore. Thanks for your time. I appreciate the work you do. There's so much to consider, and even though you're pushing ahead quickly, I don't know if we should be doing that. I think we need a well-thought-out document that's really going to address the needs of the immediate future. We just have such a short window left. Thank you.
Thank you. Thank you, Ms. Vale, very much for your presentation, your detail, especially around the connection with the younger population. I can tell you that there have been others that have shared that same concern, and so it is something that is clearly on the committee's radar. Those are very valuable points. Your connection with regards to the bill and its seemingly lack of connection to climate change has also been identified by other stakeholders, and so we really appreciate you sharing your comments on that. Thank you for acknowledging the government's climate change strategic framework. There is actually a forthcoming action plan. There's a draft out that still has yet to come, and so that will have some added, call it, objectives that will come with that. So there has been talk, in fact, of, consideration. Probably won't happen in the life of this assembly, given that we're in a very short period of time before the end of this assembly, but that other jurisdictions do have bills that are climate change bills, climate change acts, and that maybe it's time that this jurisdiction gives due consideration to that as well. So, and it's your kind of commentary that is respected in that regard. I want to thank you again for presenting on Bill 39, the Environmental Rights Act, and maybe if Mr. O'Reilly, it's down to you. Questions? Please don't tell me you don't have any. You must have.
Thanks, Mr. Chair. I've always got questions, but I wanted to follow up on one of the points you made, that regular MLAs did recommend that Cabinet develop a Climate Change Act in response to a rather critical review of GNWT's efforts on climate change by the Auditor General. That recommendation was rejected by the Cabinet, but that's not to say we can't pursue it as regular MLAs. But you raised a number of concerns around what might be called a lack of transparency and access to cabinet and so on. I just wanted you to know that there is a Rules and Procedures Committee. I chair that, but there is going to be a review done of Part 3 of the Executive Council and, Legislative Assembly and Executive Council Act. Part 3 deals with conflict of interest. There will be changes proposed to that section of the Act, so there's going to be a separate process, a separate committee that will deal with transparency and some of the issues that you've raised here in terms of potential conflict of interest. So there'll be another avenue, I think, to pursue some of those matters. I would also say that there is a meeting disclosure section on the Executive and Intergovernmental Affairs website where there's monthly reporting of ministerial meetings. You may want to check that and whether the adequacy of that meets your needs, but there is some reporting done, so you may want to check that as well. But thanks, Mr. Chair.
Thank you. So not a question in there, but some comments, and we, again, appreciate what you have to offer this evening. Thank you. Okay, at this point, folks, we have reached the 9 o'clock hour, and I'm wanting to get a temperature for those remaining as to whether they would care to just meet with us and determine on when we might meet again, because I still have 5 presenters. And so is it kind of am I getting a sense that this has been a bit of a long evening and that we can try to work with those 5 presenters to come to an agreement on when might be another time to come in and present to committee, say even just later in this week. I misspoke earlier when I said it would be tomorrow evening. This room is already booked for tomorrow evening, and one of our committee members is also not able to attend. So should we adjourn at this point, and then those who haven't spoken can meet with us or come up here and speak with us, and we'll make arrangements. Does that sound good?
I'm comfortable with that, Chair, as long as we can meet and discuss and coordinate a time tonight together.
Okay. Okay?
Yeah, I'm hungry.
Okay. So I want to thank everybody once again who have presented tonight, and for those who have stuck around this whole entire time, it is very much appreciated. As you can see, these are very important bills, and we have a lot of work before us. So thank you once again. With that, we can be adjourned, and I will ask those who haven't presented yet to please stay around for a few moments, and then we'll do some coordinating. Thank you.